Well, hello and welcome to today's webinar, Background Check Mythbusters. Um, I'm Mike Coffey, president of Imperative. I'm a career HR professional. I still do a fair amount of HR consulting, but I pay all my bills with Imperative. We're a background investigations company serving risk-averse clients, those who really need to make a well-informed decision about their hiring. And we also do a lot of business due diligence, uh, research into the individuals who a company may be looking at for a variety of reasons, maybe to bring on as a vendor or some sort of strategic partner, maybe a client acceptance situation where we've got accounting firms who need to do due diligence before they bring on an audit client, for instance, things like that. Certainly, we work with the private equity firms, family offices, and folks like that who are wanting to know about the principles in the company that they may make an investment in. But because I'm an HR guy and that's how we got into this business 25 years ago, still a good 80% of our revenue is tied around employment related background investigations. And most of my webinars and most of my conference presentations for SHRM conferences and SHRM chapters are not around background checks, or around other areas, usually things I got interested in. And about 18 months ago, I did my first presentation on AI and its impact on the workforce. And that's all anybody wants to talk about now. And I've done that about probably 24 times now over the last year and a half for different meetings. But today, because I'm very online and in the LinkedIn groups and the Facebook HR related groups, I see a lot of things around background check and employers' just use of criminal history in general that are often wrong. And so I thought, well, we'll put this together and just hit some of the high points. Now, if you go to our website at imperativeinfo.com, there's a webinars button at the top or under resources. And you can see on most of the topics I talk about today, you can see a full hour video on that specific topic, especially when it comes to using uh, asking about criminal history or utilizing criminal history to make an employment decision, how to build out your decision matrix to help you decide what's relevant and what's not. All those things we'll talk about today, and I'll mention them as we go along as well. But those are all there, and they're also pre-approved for HRCI and SHRM recertification credit. Now, today's webinar is approved for HRCI and SHRM recert credit, and I would if you're watching this live, if you're watching this webinar live on whatever today is, August 23rd, 2024, at the end of the webinar, we'll collect the Zoom information about who attended and all of that. And by the end of the day, or certainly before lunch on Friday, you will have or today is Friday, before maybe end of the weekend, you'll have an email from us with the HRCI and SHRM Recert credit information and a link to download the slides and notes. If you're watching this on YouTube on a recording or on our website at imperativeinfo.com, you can, there'll be a box below the video where you can register to receive both the notes and the HRCI and SHRM Recert credit. So that'll all be available that way. At the end of the webinar, I will also share the code that you need for the webinar as well. So you can put that code in to request the information. So that all done. I think that's all our housekeeping. Let's get rolling. Get my focus on the right screen. There we go. Oh, where's it at? There we go. So the first thing I hear a lot is, well, you can't ask applicants about their criminal history. And this has nothing to do with background checks, right? This is right up front. People tell me all the time, and I see it posted in social media and in HR groups. You can't ask applicants about their criminal history. And so let's address that. Each of the states you see that's highlighted in green here prohibit ever asking an applicant about their criminal history. I'll take a beat here for you to examine which of those states are listed in green. Exactly. Every state allows you to ask about criminal history at some point in the employee selection process. None of them make you make a hiring decision completely in the dark. and you should ask your applicants about their criminal history. We'll talk about when. So, first of all, there are limitations at the federal levels, and at the state level, but they tend to be pretty minimal, except where they're not. So let's start first talk about the federal limitations on the evaluation of criminal history. Uh, the only one on when you can ask about criminal history, when you can inquire into criminal history, is if you're a federal contractor. The Fair Chance Act from 2019 basically implemented ban the box for federal contractors. And so if you're a federal contractor, you have to follow the federal government's process to stay in compliance with your guidance in your contract. And so you can't ask until you've extended a conditional offer of employment, at least for those jobs that are going to be performed under those contracts. And under federal law, there are no other limitations on when you can ask about criminal history or, so just understand that now the EEOC guidelines in their 2012 guidance on employers' use of criminal history, the EEOC did say that they suggest that employers delay the hiring decision or delay the criminal history inquiry until after you're ready to make an offer. They suggest that you should ban the box, but that's just their suggestion. And basically, when you read the 2012 um, guidance, the EEOC is assuming that you, as an employer, probably have either no policies or very unfair policies in your use of criminal history. And so their idea there with this ban the box idea, or that you don't ask the criminal history inquiry, until later in the process, is that maybe this applicant will get a more fair shake from you once you see that they are competent and qualified and you have a lot of time invested in them. And so they want you to delay that hiring decision until later. Now, my experience is that our clients, who, I mean, admittedly, I have the smartest and most beautiful clients in the country, and so they always are thoughtful in how they do everything. And I see a number of them are online, so hi. But if you have a process that again we'll touch on it some today about fairly evaluating that information, why and that this person is really high risk because of their past behavior. I would want to know that earlier in the hiring decision so that when I'm comparing all my applicants, I may not eliminate this person who's got a higher risk, but I may focus on my equally qualified candidates who don't present that risk earlier in, if that risk is really tied to the job. And so we just use that as an initial filtering device to pick our candidates who are most likely to succeed. And you may well do that, or you may decide to wait till the end. The problem with waiting to the end, and we've got clients in ban the box states and cities around the country, that eventually what happens is you get all the way through, because your hiring manager, if you're an HR, your hiring managers want you to hire people right away. But of course, once you set up try to set up interviews and all of that, suddenly, oh, well, I can't do the interview till next Wednesday. And then, okay, yeah, well, we want to talk to some more candidates and blah, blah, blah. And they drag it out weeks and weeks sometimes. And you've got all this time invested in a candidate. And then they say, oh, yes, well, I have this sexual assault from 6 years ago, but it really wasn't fair, but it's a sexual assault from 6 years ago. And maybe you're in a healthcare environment, this person's facing a patient. Maybe you just say that's not a risk we can do. So now you got to start all over in this hiring process. That's what happens on occasion with these ban the box laws. And so I think employers making well-informed and fair decisions and having processes to do that is much better. And being well-informed means that earlier in the process, you've got that information. But all that said, under federal law, unless you're a federal contractor, there's not a limitation. But at the state level, there are in some jurisdictions, and even in the local level, some cities have their own rules. The most notorious being New York City. We'll refer to them several times today. But generally, under most state laws, these are the options you see on the left about when you can inquire into somebody's criminal history. Most states and most jurisdictions have no limitations. You can ask on the employment application. Now, personally, if you watch my webinar on about how to fairly inquire into an applicant's criminal history, how to talk to them about their criminal history. I don't like the question to be on the application, because let's say they tell you, yeah, I had a shoplifting conviction when I was 18 and that was 15 years ago. You probably don't care about that shoplifting case if that's all they've got and everything else in their history suggests they're fully qualified for this job. And so now, though, it's going to be on the app. If you include it printed on the application or even in the printout out of your ATS, and you share that with hiring managers, then some of your hiring managers, let's just face it, think they've got this unique insight into the human soul, and they're going to apply their own weird, sometimes perception of human behavior. And so they're going to see that shoplifting conviction from 15 years ago, and they are going to be biased against that candidate. Maybe the candidate is so impressive when they come in that it doesn't make a difference, but I'm a big believer that hiring managers should only get the information that your policy says may be relevant to the job. And then our role as HR leaders is to have a conversation with them to help them understand and train them on how to use this information, how to ask meaningful questions, how to dig deeper into it. Some of our clients who I've helped to write their background screening policy, they actually have a thing in a note in their policy that only if it's a medium or high risk, if it's low risk, they don't care about it, even if the applicant told them about the criminal history and it's just one offense in and of itself. They don't even share it with the hiring manager. It's only medium and high risk, and we'll talk about medium high risk factors in just a little bit. So that's one of the, that's one of the options. There's no limitations. Then in other jurisdictions around the country, and they're getting too numerous to even keep track of, we do our very best here to help our clients and keep track of city by city, all the different ordinances that are popping up. But some places allow you to ask the criminal history question after you've reviewed their application. After you've reviewed the application and you've said this person is minimally qualified, yeah, we'll go ahead and ask criminal history. Other places say you can ask at the interview. So when you give them an in-person interview, either via Zoom or in person physically, you can ask criminal history, about their criminal history there. Or then some places say after you've conducted an interview. So you can conduct the whole interview and then ask them. Others only after you've made an offer or while you're making an offer. So we have clients in those jurisdictions who, with their offer letter, also provide their written criminal history inquiry and have the applicant, if they accept the offer, also provide that information. And then there's New York City. In New York City, you can only ask about criminal history after you've made an offer that is conditional only on the criminal history information. So if you're going to do a background check that verifies employment and the person's education claims, maybe you're going to pull a driving history. You have to do all of those things, and they have to be perfect. You're going to proceed with this candidate anyway, and then you can ask about criminal history. So what that leads to is basically a two-step background check process. We're going to verify their employment. We're going to verify their education. In some cases, for some of our financial clients, we even check for certain people things like civil litigation history. We've got clients with pay-to-play regulations where they're investment firms that work with government entities, and they have to confirm that the people working with these government entities in these roles haven't made political donations in certain jurisdictions. And so they do all of that work before they ever look at the person's criminal history, because that's what the law in New York City requires. And so you have to pay attention on, if you're a multi-state employer, or in some places just multi-city employer, then you have to pay attention to the rules in each jurisdiction where you're operating. And often you'll hear this throughout the webinar, they don't line up. You often can't do a one size fits all policy that really meets all the intention of all the state, local regulations. So that's when you can inquire. And most places don't have limitations, but most often we see the it's after the interview, or at the time you make an offer that you can make the inquiry into the criminal history. What can you inquire into? So, what question can we actually ask when we're allowed to? Again, uh, in most jurisdictions around the country, no limitations based on, you can ask about arrest, and we'll talk about arrest because I know people's antennas just went up because that's one of the big ones I see a lot. You can ask about arrest, any cases filed, regardless of disposition or age. You can ask all of that in most jurisdictions, but other jurisdictions have very strict limitations. In some places, you can only ask about convictions and active probation or deferred adjudication. So if you're currently on probation, and it wasn't a conviction, but you pled guilty and you got deferred adjudication or pretrial intervention of some sort. And so it's not a conviction, but you're serving probation, maybe even have a community supervision person that you touch base with, a probation officer of some sort. Maybe you even have to do community service. You have to go give drug tests, things like that. Uh, those aren't convictions, but you're on probation. So you can ask about, is this person on probation? Then there are other places where you can't even consider that. Even if the person's currently on probation, the employer can't know about it. And you can only ask about convictions by themselves. That's the only thing you can consider. And then some places have limitations on just considering convictions in the last 7 years. And this is the one that drives me crazy. I've got clients in those jurisdictions, and there's places where, additional to all of this, where the state laws don't let me tell a client about a conviction over 7 years. And so sometimes you see something and and we'll see a sexual assault that's 10 years old, or a theft, an embezzlement case. And I know this person is going to be working in accounting. Maybe he's a CFO of this firm that they're going to bring in. And I, in many cases, cannot legally tell the employer about that item. So those are just the limitations you have jurisdiction by jurisdiction. And there's places where an employer can ask information, but then the law doesn't let them actually consider it. And we'll talk about some of that as well. The other exception here you see at the bottom of the screen is that there are exceptions. And the exception that I really want to continue to remind you of is when we're talking, there are places where a private employer, and that's what we're really addressing today, private employers can, have one set of rules and there's no limitations on what a private employer can do, but there are limitations set by the state or by the local government on what their own practices are. So government employees or government hires, government employers are limited from making inquiries until after an offer is made in some jurisdictions, where a private employer doesn't have that limitation. So just be aware that if any of you who here are government employees, your own policies and your own ordinances or state laws may limit the government's ability to do this, but not private employers. And I just realized I've lost my chat. I want to make sure I get all the chat, if there's any chat things. Okay, there they are. Okay, so you can drop, as we go through this, I'm trying to pay attention to questions and answers. So if you have questions or anything along the way, go ahead and drop them in and I will try to answer them. And so we'll go from there. So the other one, and I promised we'd cover it, is employers can't consider arrest information. You hear that a lot. And so let's talk about that. Under federal law, there is no prohibition on employers considering arrest information. This is probably the biggest criminal history myth out there. You hear it all the time. It's illegal to consider criminal history because a criminal history doesn't mean the person was convicted. That's true. Doesn't mean the person is convicted. But there's no law that says that. Under Title VII, the EEOC's guidance on the use of criminal history, which is all about Title VII, says, and this is a quote right there in that box right there, the fact of an arrest does not establish that criminal conduct has occurred. I just said that. We agree. Arrests are not proof of criminal conduct. That's right. Just the fact that somebody is arrested doesn't matter. Many arrests do not result in criminal charges or the charges are dismissed, right? Okay, that's great. An arrest, however, it goes on to say, may in some circumstances trigger an inquiry into whether the conduct underlying the arrest justifies an adverse employment action. The conduct, not the arrest, is relevant for employment purposes. So you ask about an arrest. Here's what happens. You ask about an arrest and say, or you find an arrest that maybe your background screening company tells you about it, or you include it in your inquiry to the applicant about their history. And they tell you, yeah, I was arrested 2 years ago for indecent exposure, but they never prosecuted the case. Okay, great. Well, now we know. So tell me what happened there. Tell me what, you had indecent exposure. Tell me what happened. Maybe they tell you, yeah, I walked out of a bar. I had to use the restroom. So I went into the alley and I was urinating. And and that's what happened. Maybe that's not of a concern to you. But maybe they tell you something else. Maybe they tell you that, yeah, I'd had a few drinks and we were getting carried away and I pulled my pants down and hung my rear end out of the car window as we drove by down the street, and I didn't realize the car we were passing was a police car. Well, now maybe and if it was relatively recent, maybe that conduct does tie into how this person self manages, how they behave themselves, how, what their awareness is. Um, or maybe they tell you they got arrested for, possession of a controlled substance of some sort. And you have that conversation with them, and they say they weren't prosecuted, but yes, I had this arrest. You dig into it, and so that behavior goes deeper and deeper into their past, behavior, and they're telling you what happened. And maybe they even admit, I've even had applicants say things like, yeah, well, they decided not to prosecute it because, you know, they didn't think they could prove the case, or I agreed to do community service or something like that. And you say, okay, so what was actually going on? And they admit to conduct that it was either identical to what the offense they were charged with or they were arrested for was, or they just tell you other behavior that in and of itself causes you to have concern about the risk this person presents. And so you want to evaluate that as you evaluate the entire applicant. I would argue that probably 8 times out of 10, you're not even going to be interested in that arrest information, but you never have the opportunity to evaluate it if you don't ask the question. Barbara asked for an arrest. If they tell you it was mistaken identity or something that doesn't appear to show any problematic actions on their part, is there any option other than to take their word for it? Thank you, Barbara. If all your applicants were honest, I would be out of business. The reason that you do background checks is because sometimes people lie. So that's such a good question, Barbara. Um, the reality is, if they tell you something, and if the underlying behavior would have been of concern, but you tend to believe their story, they give you a story that sounds okay. That sounds reasonable. Most of the time, it probably will. Um, and so they tell you their side of the story. Then that's where you go back to your background screening partner and say, hey, here's what we know that in Dallas, Texas, they told us they were arrested in January of 2023 for public intoxication. And that's a concern for us. This person is going to be operating heavy equipment, and we just want to really understand what's going on. And they told us that, some story, but we would like to go pull the police reports, actual copies of the police reports, and find out what happened there. Most of the time, those are available. You can get those, especially if it's in the last 2 to 3 years. And so then you get the actual copies of what really happened and compare it to the applicant's story and see if they line up. Most of the time they often do. But on occasion, what we see is the applicant told one story and you look at the police report and it's a completely different story. It's not like the difference between dark gray and light gray, and maybe the police officer and the individual just disagreed on some aspects. Sometimes it's a completely different story, a different place, different everything. And so always verify what the applicant told you. I hope that's helpful. Barbara, thanks for that question. That was really helpful to me. So given all of that, that's the arrest information under federal law. Then there are a couple different options under state law and local laws. Most often, there's no limitation on that. That's the most common, that employers can consider that. But then you still need to go back to look at the underlying conduct and figure out what that underlying conduct was. What is it reasonable for you as an employer to believe occurred? And then you don't have the right, you don't have the responsibility of guilty beyond a reasonable doubt in the employment context. And so, what's it reasonable for you to believe occurred? And is that relevant to this job based on the responsibilities of the job, the nature of the behavior, and how long ago it happened? And the whole applicant, we want to look at the entire applicant and see what else happened. So, but then there are those issues where the state, many states only allow employers just to consider convictions or active probations, things like that. So they may be your inquiry needs to be very, very narrow, and you don't ask about things that you're not allowed to consider. And so you need to, again, go back to your jurisdiction, state by state, city by city in some cases, and really pay attention to what you're allowed to do in those jurisdictions. That's why some large employers, big retail box stores, big, companies with hundreds maybe of locations across the country, they all distill it down to only looking at convictions in the last 7 years. They're missing a lot of relevant information, but the administrative burden may be more expensive of keeping track of all of that and risking doing it wrong at that scale than just saying, okay, we're going to take our chances knowing we missed some percentage of cases out there that would be relevant. We're just going to go forward and have this blanket convictions in the last 7-year policy. And that's kind of, their choice. That's how they decide to proceed, and God bless them and good luck. So here's Coffey's best practice on this. As part of a structured system to ensure that you're meeting business necessity, that you're really looking at business necessity, and you're complying with all the laws that are relevant to how and when you ask about criminal history, ask a very robust criminal history question as early in the selection process as possible. Why invest a lot of time in an applicant you're not going to move forward with, or that you've got better candidates based on this information? I'll give you another example of this. That we've got clients around the country who are nanny agencies, and these nanny agencies send people into people's homes to do interviews. And I want, if you're sending a nanny or a housekeeper or a driver into my estate, my aspirational estate, I wouldn't say I've necessarily got one now, but I want to know that they have a criminal background check before they come in and see all the good stuff I've got sitting around my house. But in some jurisdictions, they can't legally do that. And those are the kind of challenges because they haven't made an offer of employment yet. They're just doing the interview. So there's that. Let's move forward. You can't make employment decisions based upon criminal history. I actually hear that from people from time to time. And it's a question people ask. Can I really, if I order a background check, can I really make a decision based on it? Well, yeah, you can. Under federal law, you've got Title VII that does govern this idea of a disparate impact. Griggs v. Duke Power created the idea of disparate impact, and then Green versus Missouri Pacific in 1975, I believe it was, applied that concept to criminal history. And basically, the short version of Griggs is, or of Green versus Missouri Pacific, is that African Americans, in that context, African Americans are arrested, prosecuted, and convicted at a higher rate than the white population. And so if you have a criminal policy that just says, we're not going to hire anybody with any criminal history, you're going to create a disparate impact against African Americans than you are the broader population. And so under Title VII, it's disparate impact. And so we have to have an extreme, a specific business necessity for this policy that's creating the disparate impact with no other viable, alternatives to it. And so in the Green versus Missouri Pacific decision, the court suggested, it didn't mandate, but it said employers should probably look at the nature of the offense, the relationship of the offense to the job, and the time that's passed since the offense. Was this 5 years ago or 20 years ago? And what else has happened? Look at the entire applicant and get an idea. Those are called the green factors. You hear those referenced a lot. A lot of people don't know why they're called the green factors. They think green is like go, thumbs up or something, but it's actually from the Green versus Missouri Pacific case. And Then the EEOC guidance that came out in 2012 does mention the green factors, and it says employers should use the green factors. Okay, that makes sense. And then they added in this thing called individualized assessment that you are not going to find in the law or in statute anywhere in the federal law. It's not in Title VII. It's not in a court decision coming down. But the EEOC says that you should consider these other things, the facts or circumstances surrounding the offense. That makes sense. The number of offenses for which the person's convicted, the fact that the person was older at the time of conviction, because there's some statistical stuff. And this is where they get kind of weird because they're asking us to be social scientists and understand this information. But this is all a suggestion from the EEOC. And so you go through there, and I need to add a bullet point I see there, but you go through, they want you to go through, and basically it boils down to giving the applicant an opportunity to tell their side of the story and consider whatever additional information they give and see, does that make sense to us? And there are ways to do that. I've got a webinar on the website talking just about this kind of information, how to fairly and legally evaluate criminal history information. So I'd suggest you go look at that. So let's look at city by city and state by state. Many jurisdictions don't have any limitations, but then some jurisdictions do have limitations that say that the criminal behavior has to substantially, or it has to directly relate to the position. And often these laws have been around for a number of years now, but there are very few tests of what those laws really mean. There are very few court decisions describing what substantially or directly related means. Like if honesty is a requirement for every job. So if somebody has recently been convicted of something, that's overt, fraud or something like that, I would argue that's directly related to the job. But this is one of those situations where when you encounter the information, you want to go back and talk to your legal counsel and say, this is a concern for me. Do you know what the Human Rights Ordinance Enforcement Agency in our city has said about this previously? Or maybe if it's a state law, what are the rulings on this? Because it's often very vague. Many of them just say you have to follow the green factors. Again, the age of the offense, how it's related to the job, but it doesn't have that directly or substantially related requirement, and how long ago it happened. Then some actually require an individualized assessment, just like the EEOC suggested, and they've put it in some states have put it into their code. And then some have just their own wacko kind of really elaborate things employers have to do, which you can see right there. This is an example from New York's Article 23A, and I've highlighted the three that I think are really challenging for employers. I know they are because I've got clients in New York. The first one being the policy of the state to overcome the stigma toward unnecessary exclusion of persons with criminal justice involvement. So in other words, you have to consider making an employment decision, what the public policy ramifications of that are. That's just kind of nuts. That's not what a business is in business to do. You're doing background checks to protect your own, mitigate your own liability, your own risk, not to worry about the state's interest in these things. But those are all things there that are highlighted there that are kind of interesting about Article 23's requirements. So again, city by city, state by state. Most places don't have limitations, but the ones that do, you really need to thread that needle pretty carefully. And so what's my best practice here? Have a policy on how you're going to review criminal history. And before you ever meet your applicant, know what kind of behaviors, past behaviors, are going to be high risk or medium risk or low risk. So if somebody had a theft by check from 10 years ago, that's probably low risk in and of itself if that's all this person's had. But if they're going to be a supervisor, like an IT manager, maybe they've got an assault, battery, or domestic violence case against them in the last 7 years because they're directly managing people. We're going to call that high risk. Doesn't mean we're not going to hire them, but it means it's high risk. We're going to have a policy that says if somebody's high risk, but they're still our most qualified candidate who will work for the price that we're paying, then we are going to have a VP level signature before we bring in somebody who's high risk in this role. That's, and then maybe if it's medium risk, just the manager approves it, or it's a next step up manager approves it. And if it's low risk, maybe nobody approves it. Maybe that nobody even is aware of it except for HR. So and I've got a webinar out there. I'm putting this kind of information together, and it'll make your life so much easier. It takes a couple days to put it all together. When I'm consulting with clients to build this out for all the different positions in an organization, but it makes your life so much easier because now you've already know, and you're so much more defensible because you don't have that issue that says, well, this person, you didn't really consider this person fairly. Well, no, before we even met the person, we already identified the risk associated with the job. And now we're laying it out and we followed our process and our policy about how we review it. Uh, it's very unlikely that you're going to get challenged on if you've got a policy in place that was set up before you ever met your applicant, because then it's going to be hard for them to demonstrate that um, that you didn't meet that business necessity requirement, even if you create a disparate impact. You shouldn't tell the applicant that the criminal history affected them. I hear this a lot. I hear, at conferences sometimes employers will tell me, kind of sotto voce on the side, oh yeah, we just tell them we found a more qualified candidate. That is problematic. Under federal law, the fact that the applicant, there's no requirements that you disclose. If the applicant told you about the criminal history and you decided not to go with them just based on their disclosure, uh, there's no requirement that you tell them about it. But if you're purchasing information from a background screening company or like the Work Number or the National Student Clearinghouse who verifies education degrees for you, things like that, then it's a consumer report. You have to follow the FCRA, which means you have to do that pre-adverse action process and that post-adverse action process, those notifications, and give them a copy of their report and their rights into the law, all the things that are required by the FCRA. I'm going to assume you all know the FCRA. I do have a webinar out there on FCRA compliance, and I suggest if you're not sure about it, watch that. But that's the only time the federal government says you have to tell them anything is if you purchased information about the applicant and made a decision about it. But again, state by state, there are requirements. The applicant provided, if the applicant provided the information, most states and most cities don't require you to tell them anything, but some do. Some cities especially require that you identify the information that affected the decision. So if they told you I've got 5 different criminal convictions and one of them was an assault, and you said, well, because we work with very vulnerable populations and assault in the last 5 years eliminates you from consideration, you have to tell them that. Some make you give, like New York City, makes you give very detailed documentation. Those Article 23A items I mentioned from the New York State statute. New York City makes you document all 8 of those things and give the applicant a copy of it. An employment law attorney in New York City that we've worked with a client said, yeah, we just call that Exhibit A. We assume that if this goes south, that our client's notes on how they complied and what they gave the applicant is, will be Exhibit A, and they recommend that their employers give that information to them first and let them review it, their legal counsel review it and dot the I's and cross the T's before they give it to the applicant. Some do require you to wait a certain number of days. So you tell the applicant, you told us about this record. And so based on what you told us or what additional research we did, we're inclined not to move forward with you, but you have to wait a certain number of days, 5 days, typically 5 to 7 days, to give the applicant an opportunity to come back to you. And again, that's state by state. There's nothing that requires you to do that on the federal level when the applicant just told you about it. Now, again, if it's a background check, a consumer report, most states don't have anything additional to FCRA, but some do say the same things that we talked about. You've got to tell the applicant, what information specifically is affecting the decision. In some jurisdictions, New York City being most common, where you have to give them actual documentation defending your decision and how you can, you went through all the factors that the government required you to. And then in those jurisdictions, you have to wait a certain number of days. So here's Coffey's best practices here. consider the whole applicant. Why do you want to make it harder on yourself to hire people based on their criminal history if they're the most qualified person, and if everything else in their conduct suggests they're the most qualified, but they've got something that maybe is even high risk, but it was a number of years ago? Let's look at the whole applicant. Let's see if this person, if there's a way to move forward with this person. And then I'm a big advocate of transparency and this, all of this stuff. So even if you don't have a mandate under the law to do it, share with them. Yeah, well, as you told us, your criminal history, included this item, and because of our risk aversion, the kind of people, clients we serve, the kind of responsibilities in this role, we weren't comfortable moving forward with you at this time. I hope you understand that. And most of the time, the applicants will say, "Yeah, I get it." They're not going to be thrilled with it, but they understand why. If you're open and honest with them, show empathy. Don't be a jerk to them. They were probably excited to come work for your amazing organization, and now they've lost that opportunity because of their past critical judgments and error. Critical error and judgments. And so, go ahead and be sweet and lovable to them. And don't say you'll never work here. It's a not now, or you're not right for this position because of this. But in the future, will be, if you see a position that would fit, that you'd be interested in, please reapply. We'd love to talk to you about it. Questions here. Today's tight labor market. Are employers skewing towards not being as concerned with criminal backgrounds to fill open positions? Some are. Thank you, Susan. The question is basically, are people more forgiving of criminal history than they should be, or than they were previously because it's harder to get talent? In some cases, yes. But in reality, if they had a really good policy that's really well evaluated to the risks, and they're really saying, this is high, medium, or low behavior, then I recommend clients not really change those high, medium risk. We just document how we made our decision in this time. We had, 3 qualified candidates, and this one's our most qualified candidate, even though they've got this higher risk or this medium risk thing. This is who the manager felt most comfortable with because based on their skills and their competencies. And this is who we're moving forward with. Just document that. Don't change your policy to make, to bury your head in the sand or say, "Oh, I don't even want to know this stuff now." Because that's a mistake. And that's what, if something goes wrong down the road, it's going to be harder to defend because you've purposely not asked about criminal history. So you don't want to do that. You want to have a policy in place and a process in place where you're making a well-informed hiring decision that's defensible if you ever get challenged down the line. I hope that helps, Susan. Another question for remote workers: do you follow the business location jurisdiction and the employee's jurisdiction, or which is ever is more favorable to the applicant? Thank you, Barbara. This is a talk to your lawyer answer because it depends on how those ordinances are written sometimes. I see most employers paying attention to the law where the job is actually located. And so if it's remote, the job is located in Seattle, Washington, because that's where that person physically sits. That's the law that most employers are following, which again creates a whole bunch of headaches, right? Because maybe that's the only employee in Seattle, Washington, and you don't know what the rules are in Seattle, Washington. So you have to work with counsel or do your own research to figure out what that is. But for remote workers, that's generally it. It gets more complicated where I am in Fort Worth, Texas. Pew pew in Texas, where we don't have any limitations like this unless you're in Austin. And so I'm hiring somebody who lives in California, let's say Los Angeles, which is pretty restrictive. Which rules do you follow then? They're going to relocate to come to work in Texas. So do you follow the Texas rules or do you follow the Los Angeles rules? Certainly California, I'm sure they would say you have to follow the California rules because this is a consumer protection law for California citizens. I see employers go both ways on that. And I would argue that most employers, I think, if they're relocating an employee to their state, are following their state or their local jurisdiction's rules. Hope that's helpful, Barbara. And we'll keep going because this is moving fast and we're running out of time. Employers shouldn't consider off-duty conduct. I hear this a lot too. If it wasn't on the job, it's none of employers' business. And maybe to a certain extent, that's true in some behaviors. I certainly, when I was in my young 20s, long ago, I probably didn't want my employer looking over my shoulder all the time when I was doing stupid stuff. Unfortunately, none of that really impacted the hiring decision or the workplace, my ability to get the job done. Although there's probably a couple times when I was an intern in college where on a Friday morning after Thursday night partying, I may have taken a nap mid-afternoon in a men's restroom stall. But that's all that's all forgotten and forgiven by now, I hope. So let's talk about situations where a person's off-duty conduct may be relevant to an employer. What if you've got an employee who's written an op-ed piece, a letter to the editor or something like that against your organization or against your industry specifically. They're an activist against your industry, and now they're trying to come work for you. Maybe that's a red flag. Maybe that's something you really ought to consider and explore during the interview if this person's really qualified enough to get through the interview process, and then make a decision based on how do we really think this person's going to fit in our organization? Do we think they can really support the mission of the organization, given that they're opposed to the organization's activity and behavior? And maybe this employee is embarrassed. There's stuff online interviews or news articles and things about the employee that are embarrassing, that would be embarrassing to the organization if we hired them. Maybe person's just getting high profile because of maybe stunts that they've pulled or their social media presence. And maybe that, even though it's not job related, is going to reflect poorly on the organization. And then there are issues like, over the top stuff that people do on social media that really draws a lot of fire. And this is a true story. This therapist who happened to be Black and female, which I'm not sure why that's an issue, but this therapist was fired for her TikTok postings that were misandrist, which is the opposite of misogynistic. It's anti-male. And so she apparently has this TikTok presence that I've not looked at. I just read the news article about it that were, generally sexist against men. And she ended up losing her job. And I can kind of see that. As a therapist, she probably, maybe she only has to deal with women, but maybe the employer said, we need our therapist to have, less radioactive opinions and be more open minded to support our clients in their recovery, whatever it is. And so that's in that case, maybe that's relevant to certain roles. Not maybe if she's loading boxes on your warehouse dock, maybe that's not a big deal, but maybe in a therapist role it is. And then we keep seeing stories like this, right? Somebody's an educator and they're participating. They've got their OnlyFans up and they're rocking and rolling over there, making some bank. And it gets out and it's just, maybe it's disruptive to the educational environment. Maybe it's not. Maybe people need to chill out a little bit. It just depends. I don't know. But the employer, in many cases may want to understand what's going on and make a well-informed decision, a thoughtful decision about how that relates to the environment this person's going to work in and their ability to be successful in it. So there's state laws all over the place that are going to affect what you do here. There are states that have laws that say an employer cannot take action against an individual based on that person's legal recreational activities. So smoking off the job. There are employers, especially self-funded employers, who say, we do nicotine testing. We have a client that does nicotine testing. And they test for nicotine because they're self-employed or a self-insured employer. And they say, as if you're going to be in our insurance, you can't smoke on or off the job. We don't want to pay for your lung cancer. And in most states that's legal, but there are states, California, Colorado, Connecticut, Montana, Nevada, New York, and North Dakota that prevent employers from doing that. So you want to, if you're in those states or whatever state you're in, because this isn't an exhaustive list, there may be something else on, that's not out there in front of me that you may want to, so you probably want to talk to your legal counsel. There are states where marijuana is legal. and an employer can't consider somebody's off-duty conduct, use of marijuana, and even alcohol. If somebody you find out that they at a party with other employees on a Friday night and they got carried away and off campus, unwork related, just happen to be people from work there, and gets back to you in HR or in leadership that this person made an ass of themselves, then in some places, if it's not illegal, they didn't get a DWI or a ticket for public intoxication or whatever, maybe there's nothing you can do about it in those cases. So you need to understand what the law is in those places. And then many more states have protections for political conduct and politically motivated speech and behavior. While you don't, in most states, you don't have a Fourth Amendment constitutional right to free speech in a private employer setting. Some places say political activity, including peaceful, non-criminal participation in protest, is protected. And so you need to be aware of that in your jurisdictions if you're going to consider off-duty conduct. And again, this is the minority of states in those cases. And then all the states that have off-duty conduct laws all say criminal behavior is not protected. And so, whatever, if it's criminal behavior, you look at the underlying conduct, just like it was arrest. What do I think this person did off duty? What came back to me? What can I do to try to verify what happened, get their side of the story? Those kinds of things. Social media posts, we'll talk more about social media in a minute, around drug use or even trying to sell drugs, things like that. Those are always going to be something that an employer probably needs to know about. So my best practices here: talk to legal counsel. Don't ever overestimate the harm. Sometimes we see something or we hear something and we want to freak out about it. Maybe we don't freak out so much. Let's say, what's the real harm to the workplace, to the environment? What's the real risk here? What's the institutional reputation harm we may face? Then give the employee the opportunity to make it right. Maybe if it's just some social media post that they put up, which we'll talk about more, maybe they just take it down. Or maybe you just say, hey, this is the kind of behavior we really can't have. This is the impact it could have on the organization. We need you to, kind of tone it down and have a little bit more self-management. You don't have to fire this employee in some cases, and allow for civil disagreement. If just people, you know, disagree on politics. I showed Black Lives Matter. I showed January 6th. I think I showed, what was the other one? The Gaza, Israel stuff. There are a lot of protests out there. People like to protest and they think they're right. And the people who disagree with them think they're right. And so maybe we need to work more on having civil disagreements in the organization and working together to execute the mission of the organization, regardless of what people are doing off duty. But there are times where it's going to impact this, where, because it now, there's risk involved because of this off-duty conduct, or that its reputational harm could happen to the organization because of that. And you have to take action. And then, as I said, I hear a lot, social media is off limits. Employers can't consider my social media. Not so much. It used to be back in the days before social media that, somebody would take pictures at parties of us drinking and things like that. And it wasn't, wasn't a big deal because it wasn't out there following us forever. I'm sure there are people I went to college with who have a shoebox someplace full of pictures of me doing some dumb stuff, and I hope their house burns down. But now people put all their stuff online and it follows us. And so what does that really mean for us as employers? What's relevant and what's not? Well, sometimes stuff people put on their social media is relevant to the job. This is the lawyer here from North Texas, where I'm located, who was fired because he was at the outside of the Capitol on January 6th. And he said some things that his employer thought were inflammatory and would have reflected poor on the law firm he worked for, and they fired him. They were protecting their reputation. And if you do dumb stuff off duty and you're in Texas where there's no laws on that, then it's going to have an impact on the employer, and they've got a right to protect their reputation. And then there's the ultimate story about social media is Jared Loughner. He, you may remember, he's the shooter who shot Gabby Gifford, Representative Gifford, and killed, I think, two other people at the same time. This wasn't an employment related shooting, but had it been in the workplace, within hours, his YouTube and his crazy social media post and his weirdo manifesto was all over the news. Had it been a workplace shooting, the employer people would be asking, and the plaintiff's lawyers would sure be asking the employers, why didn't you know anything about this? Why, how did you let this person in this organization and create this risk for your employees, for customers, and things like that? And there have been a number of cases where there's been workplace violence of some sort. And then after the fact, the postmortem and looking at the circumstances showed that, yeah, there were things on social media that could have been a red flag that had we known about it, maybe we wouldn't have had this person in this role. And I spoke, of course, about the therapist and um, the OnlyFans model. But here's another one. If Reddit is the biggest rabbit hole on the internet, but there's a whole group called Anti-Work, and people are on there telling about ways that they screw their employers over. And often they use fake names, so you don't know who they are. But if you can ever tie it back to an employee, wouldn't you want to know if this person who's bragging about the ways they steal company time, and you tied it into an employee or a prospective employee, an applicant, and they were dumb enough to use their own name. And by the way, on Reddit, I'm Mike Coffey, so I don't have any hidden stuff, so you can find my stuff. But um, maybe you want to know that. Or maybe this is your applicant who's starting work tomorrow morning, and you see this and oh, they're thrilled to work here. So maybe we have a conversation about this. Maybe this is relevant to, is this really somebody we want working for us? And maybe if you're just paying minimum wage or the least you can possibly pay for the role just to get a warm body in the seat, maybe you don't care. But many organizations probably would. And then there are all kinds of political statements people put out there. In many states, those may be protected, but maybe there's other times where it's relevant to the job. If you're a defense contractor and one of your big clients is Israel, or you're in a state and you're contracting with one of the states that has policies against disinvestment from Israel and things like that, maybe the person who posts from river to the sea on their Twitter, uh, maybe you've got to have a conversation with them, or at least a consideration of whether this is the right person to be um, our vice president of social media, or our vice president of public relations, or something like that. Or maybe you work with law enforcement, and the idea that you're going to have an employee who's going to be dealing with your law enforcement customers who's posting stuff about all cops are bastards. Maybe that's an issue for you. And certainly all cops are bastards. Maybe this is somebody who's, going to have to testify on behalf of the organization. If you're a forensic laboratory or something, and if this is something that the plaintiff's lawyers could pull up to discredit that person, maybe that's a concern. Maybe you need to know about it. And if you're a meat processing plant or something like that, a cattle raiser, somebody who's an animal rights activist and is really opposed to what your industry and your organization is doing, maybe that's relevant. And then threatening, coercive, illegal behavior. If somebody's posting, God forbid you be shot in the head while sitting in your car, one can only dream. We back the blue. Maybe that's just a friendly statement, but maybe that's concerning. Maybe that's not the kind of behavior you want in the organization. And certainly, again, somebody selling drugs online would be a red flag, and you see this a lot. And so maybe that's a red flag for bringing somebody in the organization. So what are the risks of not reviewing social media information? That you're going to miss threatening or coercive behavior. You're going to miss criminal or antisocial behavior, drugs, racism, sexism that may be relevant to the job. And you're going to miss information that may harm the organization's reputation. What's the risk of actually reviewing the information? Looking at, getting protected information, right? You look at my Facebook, you see I'm over 40. That's my only protected class, white male. And you can get into all of those kinds of things and stuff you don't want to have in your file, or even say that you looked at or were aware of if you're ever challenged on a hiring decision. Maybe you misunderstand the context of what you're looking at. Maybe, You're using one of those AI tools to search social media, and whoever's providing that information to you isn't digging deep enough into it to understand the context. And so somebody says, I went to work today and I killed it. I killed it today at work. And the word killed it gets flagged as violence. And so you got to make sure you understand what they're really talking about. Then bias due to irrelevant information. If your hiring managers are looking at social media, this is probably not a good idea. Your hiring manager should be looking at information to say, is this really relevant? Is this to their competency, to their ability to do the job successfully, to fit in our culture, to make the company look good? And then again, the risk of state law violations. You want to make sure you understand all the laws regarding off-duty conduct in the state you're working in. So, first of all, don't ask for passwords. Many states prohibit employers from asking for passwords. New York prohibits employers from even asking the applicants what their social media handle is, much less, and along with their password versus just asking for the password. Um, the Make sure you're not doing that. Only look at what's public information that you can tie directly back to that person. Create a firewall between you and the people, all the people involved in the hiring decision, and the actual um, person who's looking at that information. So the hiring decision people shouldn't be the ones going through the social media profile, because you're going to see all that protected class information, all this irrelevant information. So have really specific guidelines about this is the stuff we're looking for: threatening or coercive behavior, drug use, dishonest or criminal behavior, things like that. We're going to have this specific list, and then somebody else is going to go through that. You can, work with your background screening company. Certainly, we do this for clients. But if you're working with a background screening company, make sure they're going through, and you shouldn't be seeing false flags. You shouldn't see stuff like "I'm killing it today," or "I'm feeling so drugged up because my allergies are killing me." Those shouldn't be coming through as red flags to you, because that's just inviting you to have a problem. They should be curating that information before it gets to you. Ensure all the information that you're actually considering is accurate, that's really your person, and you understand the context of it, that it's relevant to the role. Those things are really important. You don't want to let any of your screening tools screen out people that you actually want to work there. Don't make it harder on yourself to hire people. And then often, especially when it's already an employee and something crazy comes up, give them the individual the right the opportunity to make this situation right. Maybe take the post down. Um, I'm not a big believer in public apologies, but take the post down, or just take your social media posting private, and but just talk to them about it. Give them an opportunity. You don't want to lose a good employee or even a fully qualified candidate over something that's just dumb and it's kind of embarrassing. And we're out of time. We blew through an hour. I posted the questions. I got all these questions from uh, when you registered for the the webinar. I asked for questions, and I also got them from the Evil HR Lady group on Facebook, and some of the other Facebook and LinkedIn social media groups. It was funny because some people didn't even want to engage in the discussion on the online groups, and so they private messaged me the questions. So, these are the ones I got the most consistently. I think I could do another 2 hours on this, but we are out of time. I do have a podcast, Good Morning HR. It's the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Every episode is about half an hour long, and they're all pre-approved for HRCI and SHRM credit. And we drop a new episode every Thursday morning. So join us at Good Morning HR wherever you get your podcast. And again, if you're watching the webinar live, you should get an email later today or first thing on the next business day with your research information and how to download the slides and notes. And if you're watching the recording, your keyword, get ready for this, your keyword is myths, MYTHS. That's myths, MYTHS. And you can go get credit for that at imperativeinfo.com/webinars. Click on this webinar and fill out the form. And we will email you the link to the research credit. Thank you again for joining me today. And until I see you next, be well, do good, and keep your chin on. Keep your chin up, not on. I got my words mixed up. But anyway, have a good one. Look and see if there's any last questions. I'll answer them if they're here. I think I got them all. Perfect. Great. I hope y'all all enjoyed it. Be well. See you soon. Bye-bye.